Welcome back to the Coalition for Marriage YouTube channel. If you're joining us again, if you're joining us for the first time, privileged to have you. We are the UK's largest pro-marriage organisation, representing tens of thousands of individuals and groups who support and promote this thing, one man, one woman marriage. And, you know, I say this every time. We're not saying other things don't exist in society. They clearly do. But we think that marriage between a man and a woman is absolutely unique. It brings something very, very special to society, which we ignore at our peril. And we think we should support and promote it much more widely than we're currently doing, because it does bring about the best version of the next generation. The evidence seems to be abundantly clear about that. Now, it's a privilege to have a guest today, somebody who has written on these topics in terms of protecting people's rights of expression in these areas. Well, it's a privilege to welcome you, Associate Professor Dr. James Orr, and you're an Associate Professor at Cambridge University. Your topics include philosophy of religion. I've heard you commentate on social policy and political philosophy, all sorts of other things. James, it's a privilege to have you with us today. Would you like to say hello to our listeners and our viewers?
Hello, everyone. Very good to be with you, and thanks for the invitation, Tony.
Great. Now, James, I stumbled, as well as having heard you speak in various fora previously, I stumbled across a paper you wrote in 2016. You wrote it on behalf of an independent think tank called Res Public. And the paper was called Beyond Belief, Defending Religious Liberty Through a British Bill of Rights. And the reason it struck me for interest was because it touched on, for example, people who believe in marriage being between a man and a woman. And you cited a few cases of people going through difficult situations in the courts, often winning their situations, but actually the process being the punishment, ending up victorious. But nevertheless, there seems to be this confusion even back then, which you noticed. And you suggested that it should be dealt with by a Bill of Rights, or the paper suggested that it should be dealt with by a Bill of Rights. Any more on the background of that before I ask you a few questions?
Well, thanks for your kind words about that paper. It was for Res Publica, which is I suppose, sort of centre-right think tank in London, run by the endlessly energetic and innovative thinker of the so-called Red Tory Philip Blond, who I'm proud to call a friend. And I thought him back then and think him now one of the most exciting policy thinkers of our age in this country. The context for that paper, it seems rather dated now just because so much has happened politically since then. But the context of that paper was a fledgling commitment by the then government, headed up by Theresa May, effectively to trigger a second Brexit. I mean, that the party was serious about leaving Strasbourg, that is to say, leaving the European Convention and leaving the European Court of Human Rights. And there were various sort of pressures for that. One of them, I think, was a recognition that to get borders under control and to deliver one of the prime objectives of Brexit, at least as it had been advertised by the Brexit campaign in 2016, was to get borders under control. And there was no real way to do that, as I think has become clear ever since, when we remained under the jurisdiction of a foreign court. That is to say, when the most important, one of the most important responsibilities of any government, namely protection and control over the borders, was effectively still within a foreign jurisdiction, over which a democratically accountable government had no control. Now, that was one of the concerns, but there were other concerns too, and I think Philip and I recognized that there were opportunities here to improve on. Or at least try and put a rights-based regime on a secure footing in the domestic jurisdiction. I mean, I should say that I am myself philosophically opposed to rights-based regimes. I mean, it's not at all clear to me that the human rights discourse has delivered the goods that were promised in the wake of the Second World War. And in my view, the European Convention, though we largely drafted it, it was a Scottish lawyer David Maxwell Fyfe, who drafted it. And although we were the first country to sign it, I think in March 1951, was basically a solution to a problem affecting primarily continental Europe, emergent really of the problem presented by the Nuremberg trials and the Nazis' defense in those proceedings that they had not broken any laws. So that was the context, and we decided that we should push for a British Bill of Rights that would have tighter drafting, at least with respect to Article 9 and Article 10, or whatever the substitute provisions would be, affecting freedom of conscience, freedom of belief, and freedom of speech and freedom of association too.
So even at the time when you were doing that, so we had, as we still have, the Public Order Act, which allows open discussion of sexuality, parties to a marriage. We had case law saying that marriage between a man and a woman was worthy of respect. We had the Equality Act, which we've got now, which gives religious protections to people who believe something firmly convicted because of their faith. What did you feel wasn't already protected that should be enshrined in a Bill of Rights?
Well, so I thought there was a lot of that there was a lack of clarity over what freedom of belief, what freedom of religious belief extended to. And I thought that a lot of the case law coming from Strasbourg didn't pay much more than lip service to Article 9 rights. And that it was also that it effectively laid conditions down for all sorts of invidious circumstances where judges were having to determine what did and what didn't count as a religious belief. And in fact, inviting judges to make theological judgments about what was and wasn't intrinsic to the particular religious belief system in question. And this is a problem that goes right back to the 19th century, the so-called Scottish case that won't go down that rabbit hole, but it's always been a problem where particular to rights of religious belief. Now, the Granger criteria, the so-called Granger criteria, which came out, I think it was in 2012, it was a case, Granger and Nicholson, pertaining to somebody who had a clear philosophical commitment to anthropogenic climate change, and who it was alleged, had been discriminated against for holding those beliefs. And those Granger criteria, the five criteria that needed to be met for a philosophical belief to count as protected under the Equality Act, were quite helpful. And the fifth one, all had to be met. And the fifth one, I think you alluded to earlier, that the belief in question must be a belief worthy of respect in a democratic society. For example, a commitment to traditional marriage was both protected, should in theory both be protected as a philosophical belief, provided it was deemed to be a belief worthy of respect in a democratic society. But the Granger criteria don't need to be met if you're claiming that it's a religious belief. The Granger criteria only apply to protection of a philosophical belief, which is a separate protected characteristic under Section 4 of the Equality Act.
And since then, of course, a lot's gone under the bridge since the writing of that report. And perhaps we'll finish with, what did you learn from it and where do we go from here? Because it's still extant, some of the things we're talking about. But we've had, I think it was last week in the news, the case of the Catholic priest working in the NHS, where there was a conflict of protected characteristics under the Equality Act. Somebody's sexuality versus his opinion on the parties to a marriage, the rightful parties to a marriage from his religious protection belief. And the head of the particular trust concerned said, well, actually, I think the rights of the person with the sexual preference trump your rights of having religious belief, which was quite interesting. And then we've got the Kate Forbes example fairly recently, in the sense of, that there were calls being made where she couldn't possibly be allowed to hold public office because of her views on marriage. You've got the Church of England changing its position. So I just wonder if you want a couple of comments about where things have gone since the already serious cases you cited in the paper that you wrote.
Well, they're all very interesting cases, and they're all, I just could respond to each of them in slightly different ways. I mean, the first one, the case last week, I'm not quite sure of the details, but what that involved is effectively a clash of protected characteristics. And what it unmasked, I think, and what cases like it unmask, is that rights-based regimes find it, though they cloak themselves in the guise of a kind of neutrality, a sort of secular pluralist Rawlsian neutrality, where we're supposed to bracket all of our fundamental commitments about so-called comprehensive doctrines about human flourishing and the ultimate goods and so on. The reality is that you're always in the end going to be involved in a ranking exercise, that the 9 protected characteristics under Section 4 will come into conflict. We're seeing this in all sorts of different ways, not just in tensions between religious commitments and sexual orientation. The sexual orientation is a protected characteristic. You'll see it soon between sexual orientation and gender reassignment, for example. There's obvious tensions between the LG and the LGB on the one hand and T on the other that we don't need spelling out. So this is one of the kind of structural weaknesses and structural failures and problems. This is just a deep conceptual tension in rights-based legislation, creating an illusion of equality and neutrality between the protected characteristics, when you are going to get time and again and more instances where these protected characteristics are come into conflict, and where it's, again, a judge is put in an invidious position of effectively determining, according to his own moral instincts and intuitions, or more likely the zeitgeist of the times, the zeitgeist on with respect to that particular issue, how those should be ranked.
There seems to be a difference between being prejudicial towards or discriminating against, which is one thing you might want to discuss, versus holding and expressing an opinion, which is the thing that seems to be being punished.
Yes, that's right. Thanks for clarifying that. You're right. So freedom of speech, or the way it works, cashes out in university context, which is academic freedom, and a slightly different right, is distinct from the right not to be discriminated against under the Equality Act. And so there would be two sort of separate issues. Very often they're kind of merged together in the public square and in the reporting, but they are distinct. So your right to express your lawful beliefs is ought to be sacrosanct. Now, the religious belief cases normally involve the expression of a belief in some way, sometimes merely in thought, in the case of these buffer zone cases, but the expression of a belief that is then issues in some action by another party that puts you at a disadvantage or discriminates you, could be classed as discrimination in some way.
And I suppose when feelings become prominent and you get the notion of microaggressions, or people refer to feelings as violence even, that justifies actual violence in order to stop the feelings being hurt, kind of in a topsy-turvy world. And perhaps because I know you're a busy guy, and you've got to go, but so fitting into that, the potential ban on so-called conversion therapy, which is going in the opposite direction from the Bill of Rights that you, or it seems to me is going in the opposite direction from the Bill of Rights that you were recommending, into something which actually says these are things you are not allowed to say for fear of prosecution.
That's precisely what is looming, and indeed is with us plausibly already. I mean, the arguments, the public debates around conversion therapy, and a lot of the empirical evidence relied on to push through legislation on conversion therapy has been just really lacking, and it's been extraordinarily uninformed. And it's sadly one of the features of a public square that is taken over by is swept away with feelings and emotions and the psychologizing, particularly, of harm, that it's very hard for us to have a rational and informed debate. These are, perhaps it's unsurprising, these are very emotional issues. We're now into what some people call the biopolitical. That is to say, identity politics brings with it issues that relate to what are alleged to be constitutive ingredients in what it is to be me, what it is to be a person. So, as heated as those conflicts got in the 1970s, say, between Friedman-type Chicago school economists on the one hand and Marxists on the other hand, they really in the end came down to, you know, the role of state intervention in society and in the markets, and the proper ownership, the degree of ownership, and the means and distribution of production and so on. These didn't affect the person in quite the same way. And what we're seeing now, I think, as you noticed, is what Carl Trueman calls the rise and triumph of the therapeutic self.
Yes.
Where notions of harm cease to be what John Stuart Mill talked about in On Liberty, where the proper limit of sort of my freedom ends at your nose, as it were, and we can't. That's the so-called harm principle fixes the proper parameters of individual freedom. Where harm moves from the physical into the psychological, then effectively Mill's harm principle can be weaponized in a way that has paralyzing effects on a society. Because as soon as offense and harm is psychologized, the ordinary rules of justice and the basic principles of natural justice are out the window. There's no point in objective evidence anymore. All that could count as evidence of harm is the subjective declaration of the alleged victim. And this is indeed, I think, how microaggressions are, as I understand them. This is how microaggressions are defined, namely as aggressions that lack the intent of offense or harm, but nevertheless have the objective outcome of offense or harm.
And what subjectively interpreted as harm.
Subjectively interpreted
they are harm.
Exactly. Yeah. And what this does is it removes one of the central pillars of what counts as a crime under not just English law, but under all Western systems of jurisprudence, all systems of jurisprudence, full stop. Namely, there needs to be a guilty act, actus reus, but also, and coinciding with, a guilty intent, a mens rea. And so that the sort of pernicious sort of consequences of microaggressions and those sorts of, that way of thinking about harm and conflict between citizens is that effectively a suspension of the principles of natural justice. You see this too with talk around hate crimes, you know, so that somehow if Peter murders Lucy, okay, that's murder. But if he murders her hatefully, that is somehow a different category of crime, or that should somehow feature in the sentencing guidelines and so on. This is, as soon as we're into the realm of the subjective, you don't need a jury. You don't need any objective procedural. You don't need any sort of procedural mechanisms to establish what counts as harm.
We've been a bit down that road, because I think it was last week again, maybe the week before, where the Home Secretary was instructing the police to stop this notion of recording non-crime hate incidents, whereby somebody may have reported you, James, to the police for having offended them, and the police may not have contacted you at all to investigate or make a determination, but will have recorded the fact that you've committed a non-crime hate incident. And were you to apply for teaching young children or something, that may in itself disbar you from being able to do that, which, a whole other system of sub-justice, subvertive sub-justice, if you like.
Well, what's so interesting about non-crime hate incidents is that I talked earlier about the removal via microaggressions of the need for any guilty intent, mens rea. Non-crime hate incidents remove both.
Yeah. Yes,
remove both. Not only does there not need to be any guilty intent. Hate is not guilty intent, right? There's got to be intent to commit a crime. There's no crime. There's no incident. It's just an incident. It's not a chargeable offense. And so the idea that you could have this could be recorded against you and with you for life, no matter how young you are, was quite extraordinary. And the idea that this could be cross-checked by prospective employers. Without you even knowing, in a way that was protected from your rights under, with respect to almost everything else under the Data Protection Act and so on and so forth, it was quite extraordinary. And
it is quite
thank God for Toby Young and the Free Speech Union and all the work they've been doing to persuade the government that this has to be removed immediately.
Yeah, very, very good. Although it's been in for a while now and done an awful lot of damage in its time, I'm sure.
It
You,
has.
you mentioned Carl Trueman. When I spoke to him, he said that he thought marriage was at the heart of our cultural war. And probably he's right, because all the various definitions of marriage that constitute the definitions of marriage, right at the heart of it. He struggled to suggest ways forward. I'm just wondering, how do we get back to the place where we live, even in a genuine liberal democracy, where the government's role is to enable you and I both to live our freedoms, if you like, without extending that to ever so smaller groups, whereby in order for that tiny group to live its version of freedom, the rest of us have to change what we believe is the evidence of our eyes and our ears, for example. How do we get from where we are back to where we resurrect your documents and say we need a Bill of Rights? Will that work, or what do we do? You're a gifted thinker, James. Get us out of this.
I'm not sure about that, but the first thing to say, I think, would be that a Bill of Rights. Be careful what we should be careful what we wish for. I mean, in 2016, it made sense to try and take a lead on the Bill of Rights debates. And it may still be that it comes back. But, in many ways, having the British courts determine the proper scope of freedom of conscience, freedom of religion, and so on, that may be something that you would prefer not to have, at least relative to the current Strasbourg court, which is made up of a pretty broad spectrum of perspectives on these questions, because the European Convention has, I think, 47 signatories, including judges with views that are probably, not quite on the progressive bandwagon. So it's not clear to me at all that the British Bill of Rights is really going to fix much. And indeed, a lot of these questions are pre-political and are far, far, far upstream of any policy levers or legislative levers. Though law is a teacher, and the message that a society sends, for example, when it introduces and recognizes same-sex marriage, has very important downstream ramifications. Certainly the religiously motivated arguments are now out of the question when it comes to these questions of marriage and family and so on. Even if they're sort of hovering in the background, I think they're generally speaking not helpful in a broadly secular public square. I think the better way to make the argument is to show the extent to which flourishing, intact families contribute to the good of all. And then I think the task is one for debating in the public square by appealing to and marshalling evidence in favor of the benefits that intact family formation, successful family formation, intact families bring to the common good. And so, that then to start looking at ways in which we can introduce policies that benefit everybody. And that means, by the way, not nationalizing childcare. In my view, means taking,
which we're doing more and more of, aren't we? Really,
I know that a lot of the Conservative Party was not on board with that, but the idea that we should be incentivizing mothers and fathers to release their children, put their children in childcare at earlier and earlier ages, rather than say making tweaks to the tax system that make it easier for one of the parents to spend longer at home with the child, whether that's extending maternity leave or extending paternity leave, or taxing households rather than individuals. The tax penalty, really, or the absence of any meaningful tax benefits playing a role in successful flourishing of families. Is nothing short of a scandal for a Conservative government.
The irony, of course, that we tax people as individuals, but benefits are calculated on a family basis. And you think, well, let's be consistent on both of those, at least, and not do one without the other, because that's disincentivizing families sticking together in many cases.
Yeah. And so, just relatively simple tweaks. For example, making personal allowances to be transferable between spouses. That's a way of recognizing marriage. Cameron talked a lot about it. The coalition government talked a lot about it, but did very, very little. I mean, Cameron was his argument for introducing same-sex legal recognition of same-sex marriage was that it was a conservative approach, and the reason for that is that he thought that supporting marriage was a conservative position, but he didn't then deliver on his stated commitment or his stated belief that marriage
supporting marriage
in society in any other way.
Yeah, absolutely. James, honestly, it's a privilege to talk to you. Nice to have you on the side of real marriage and promoting real marriage as the thing which just brings about the best version of the next generation. Given that other things clearly exist in society, let's promote the thing that does good for the largest number of people. It makes absolute sense. Absolutely right. Can I thank you for your time? Thank you for your contribution. I know you've got to rush off for something else now. It's been a privilege to talk to you. Associate Professor James Orr, thanks for your time.
Thank you, Tony, and thank you for all the work that you do and all the work that Coalition for Marriage does. It's great to see you go from strength to strength.